This is Utah versus Kouri Richins. She is accused of poisoning her husband in a Moscow Mule. She is also accused of the attempted murder of her husband Valentine's Day. He ended up dying on March 3rd. So there's an attempted murder and a murder. You may remember the case from her walk the dog letter or her Google searches, because your phone will tell on you, and she was Googling luxury prisons for rich people. She was also trying to smuggle Crest white strips into the jail with her former attorney. This is Judge M with the glorious beard, who we all adore, who seems to hate the cameras, even though if Hollywood cast this man as a judge, people would be like, no, it's not believable enough. Nobody's gonna believe he's the judge. So this case has garnered a lot of local interest because when Kouri Richins was arrested, she had just gone out and started doing press for a children's book that she wrote about grief, about the loss of her husband. And the more that comes out in this case, the more that the word loss seems to not be a loss at all, because the more we learn through these motions, and we have gone through the preliminary hearing, the very substantial detention hearing, a second detention hearing, Kouri Richins thought that if her husband died while they were still married, she would get the money from his half of his business. What she didn't realize is that he had some concerns and had taken her out of his trust. So his sister became the executor of the trust to take care of himself and the kids. She didn't know that. She was girl bossing way too close to the sun. We now know that immediately after the passing of Eric Richins, a year before Kouri Richins was arrested, she got into a fight with her sister-in-law who was in charge of the estate because Kouri Richins was trying to get into a locked safe, and the sister-in-law was like, that's not yours, you can't get into it. She throat punched her sister-in-law the day after her husband died. It took law enforcement quite a while to get into her digital devices, but once they got into her digital devices, that's when everything unraveled. That's when you have the Facebook messages of her trying to procure fentanyl, text messages of her trying to procure stronger fentanyl. Then you get the interview with the person who sold it to her is like, I'm not going down for her. I'll tell you what you need to know. And on and on and on. So this case has quite a lot of information. There are some discovery issues outstanding, like, will the walk the dog letter be admissible? Will the girl boss journal, the orange journal, be admissible? The journal seems to have her musings about things not working out on February 14th based on representations by the prosecutor. The prosecutor, by the way, Mr. Bloodworth, is just his own vibe. Also directly stated in court, any law nerd on the internet knows this as the walk the dog letter. Hi, Mr. Bloodworth. We appreciate you in this case. Appreciate this judge. The defense attorneys are doing their job. I find from everything we've seen in court, the evidence in this case is very strong. The defense is doing their best to keep out some of the evidence. They're not going to get very far on that. And the defense is trying to change venue, which is why we're in court today. The court had originally said that he would expand the jury pool. And then the site judge was like, immediately, no, Your Honor, you can't bring jurors in from Salt Lake County, and immediately no. So the judge had tried to expand the jury veneer. He also says veneer, but had tried to expand the pool of jurors. It was shut down by the courts above him. And there was an appeal on that. There is still some appellate stuff pending regarding that. And now we have the motion to change venue years after this case was brought to court. This was supposed to go to trial at the end of the month. We are on the precipice of trial. And now the motion for change of venue. And that's where we're going right now. This was from Monday.
And if you're going to make a motion to continue the trial to allow that position for interlocutory appeal to be considered and decided, sooner the better.
We'll do that now.
Go ahead.
We're making a motion to stay the proceedings and to continue the trial while we seek an interlocutory appeal.
And is it your intention? Oh man, I got to ask you some very pointed questions here. Do you mind? And if you don't know the answers yet, that's fine. Have you discussed with Ms. Richins
Yes.
the certainty that she will remain in custody while that process plays out?
Well, we would move to reopen the matter of detention, but we've discussed with her that that is a possibility.
I am disinclined to reopen the matter of detention. So let's be very clear here. There are no material changes in circumstances since the last time I considered the issue that I'm aware of.
Well, a change in the trial date is a material change in circumstance.
But you're the one asking for it.
All right. Well, we just want to make a record. We believe that is a material change in circumstance, that the trial date is going to now need to be moved. She's been in custody for almost 2 years, and there are certainly circumstances, there's a set of conditions under which she could be released and not be a flight risk and not be a danger to the community.
Let's assume that she's not going to be released and that I find that there has not been a material change in circumstances based upon defendant's request to continue the trial. Have you discussed with Ms. Richins the fact that the interlocutory appeal process may take years?
Well, we'll take an emergency appeal. I don't think it will take years, but we know it will take a minimum of months.
Okay. I
And
understand.
we have discussed that with her, yes.
Okay.
Your Honor, to that point, can we get maybe more complete speedy trial waiver?
Defendant's motion to stay pre-trial proceedings in this case from this point forward is granted as unopposed. The court will issue a written ruling that incorporates its ruling from the bench regarding the motion to change venue so that there are no impediments to defendant's ability to seek appellate review on the motion to change venue. Ms. Richins, I wish you the best of luck. The court is in recess.
At the end of the day, in the Kouri Richin's case, the court denied one defense motion and granted 2 others, which will substantially change the pacing of this case. After a thorough hearing, and we saw the same expert on the change of venue motion that the defense used in the Kohbeger case, the court denied the change of venue motion and made a really thorough record that if the appellate court disagrees with the court's findings here, that the court believes that the proper procedure going forward would be to allow the court to bring a jury from Salt Lake County up to Summit County versus sending the entire case from Summit County to Salt Lake County. Different than what happened in the Kohbeger case, where the entire case was moved from Latah County, near where the crime happened, more than 300 miles away to Boise. Here, Summit County and Salt Lake County, where Salt Lake City is, are much closer together. They share the same media market, etc. So the court denied that motion for change of venue. Earlier in the case, all the attorneys had asked that the court expand the jury pool and pull jurors from both Salt Lake County and Summit County. And the court had said, yes, we can do that. And then the site judge or the presiding judge said, no, you can't. And then the defense took an interlocutory appeal, and that went up on appeal. And the Supreme Court in Utah said, you cannot pull jurors from 2 counties, and findings have to be made on this type of motion to change venue before you can grab jurors from another county. And the court denied that motion from the defense today. The defense indicated immediately that they are going to take another interlocutory appeal, which means an appeal while the case is ongoing versus a conclusion has happened and then an appeal is made. So the defense is taking another interlocutory appeal on the issue of change of venue. And they then immediately made a motion to continue the trial and stay the proceedings. A jury was supposed to be selected at the end of April in this case, with evidence starting the first week of May. But that's not going to happen now that the court has stayed the proceedings and is allowing the defense that interlocutory appeal, which they have to, and has continued the trial. If you're going to ask me, continue the trial till when? We don't know. It depends on how quickly that interlocutory appeal moves along. But what we do know is that Kouri Richins seemed pretty upset with the delay, or the fact that the court immediately said that the court would not reconsider the status of Kouri Richins' detention. The court said that he did not find the defense request for stay and a continuance of trial to be a change of circumstance outside the defense control. And the defense made a record saying, we were prepared for trial. We are not doing this to delay this case. We are not doing this to gain more time. We as the defense team believe that Kouri Richins' best chance for a fair trial is with a Salt Lake County jury, not a Summit County jury. The court said, yes, I agree with you. And then the defense asked again for an expanded gag order and talked about the media in this case. And the court talked about the media coverage of this case multiple times during this hearing. This judge made it very clear that he is incredibly displeased with the media coverage of this case, which he said was incomplete and was speculative. He said there are commentators on this case talking about it with no knowledge of the case, that the facts of the case had not been, well, completely vetted out, and that he found the coverage of this case to be, I think the direct quote from the court was, an indictment on those media outlets and the media culture in general. It is very clear throughout the court's comments on the record today that this court does not believe that the media coverage in this case has been accurate, complete, or fair. I don't know exactly what media coverage he's talking about. Most of the media coverage I've seen of this case have been clips of what's happened in court. It has not had the pervasive media that we've seen in other cases. However, do you know what came up in court today? A whole lot of arguments mirroring the Karen Reed case. And in fact, the Karen Reed case got a name drop in court today, as did the Kohbeger case. And they talked about the fact that when you look at the standing in the community of the victim, Eric Richins, vis-a-vis Kouri Richins, that Eric Richins' family has a long-time connection to the community and has hunting land and a library or something, but that Kouri Richins was essentially an outsider. And the court corrected the record and said it seems that Eric Richins and Kouri Richins both moved to the area in 2012 after they were married and built their lives in the community together. But you can see the defense attorneys trying to make similar arguments to the Karen Reed case when these cases could not be more different. The coverage of the cases could not be more different. And the coverage of the Richins case pales in comparison to the vociferous media coverage of the Karen Reed case. And that's been true since the beginning of the case. I think the most attention the Kouri Richins case is going to get is midway through trial when people start hearing about it. It will pick up attention as it is underway, but it has not had attention outside of updates on the court dates very often. And not streaming, I think, might be a part of that because it takes a couple days from a hearing before we even see coverage of what happened in court. So I don't think this case has the type of media coverage we've seen in other cases, but there is a lot of local interest, like there are in many cases. So let me know what you think. We're not going to see a trial on this case yet. I don't know if we're going to see a trial on this case this year. I really like this judge, even though he hates the media. And the prosecutor did say, that all the law nerds on the internet do call the walk the dog letter, even though it's docket 214. So yeah, I'm invested.
Sergeant Barry, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
It's docket 214, but every law nerd on the internet calls it the walk the dog letter.
Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.